Good morning, sir. Um, this is my report about the Criminal Justice System, Chapter 2, which is the law enforcement pillar. Lesson 1, Introduction to Law Enforcement. Law enforcement pillar, for the purpose for this presentation, refers to the police, specifically the Philippine National Police. Police is a generic term referring to any government agency that enforces law. So what are the functions of law enforcement pillar? Its goals are all aimed towards prevention of crime and disorder, preservation of peace, and the protections of life, property, and individual freedom. So, who a law enforcement officer? It refers to someone who enforces a law, originating from a merging of the Philippine Constabulary and the Integrated National Police. The National Police, PNP, is the civilian national police force of the Philippines. So these are the fundamental principles of law enforcement. The basic principle for which the police exists is to prevent crime and disorder. Second, the police seek and preserve public favor, not by catering to public opinion, but by constantly demonstrating absolute impartial service to the law. Police should always direct their actions strictly towards their functions and never appear to usurp the powers of the judiciary. So, what is policing? Policing refers to the activities carried out by the police officers in order to preserve law and order to the actions of a person or group in authority in order to ensure fairness and legality in an area of public life. There are styles of policing. First is watchman styles. It focuses on maintaining order. Second is legalistic styles. Police departments operating under a legalistic styles operate according to the letter of the law. Third is the service styles. It is a policing occurs in the middle and upper class societies. Policing approach. So first is reactive policing. So reactive policing. This policing is sometimes known as the fire brigade policing or incident-driven policing. Next is proactive policing. It is the practice of deterring criminal activity by showing police presence and engaging the public to learn their concerns. Third is problem-oriented policing. This policing identifies a repeated problem and then setting out to devise a solution. Fourth is evidence-based policing. It tries to seriously evaluate policing activity and perhaps using properly designed trials to see what works to reduce crime or to respond to community needs. Fifth is community policing. Department and officers must commit time to develop a partnership with the community to prevent a countercrime, maintain order, and reduce the fear of crime. Sixth is zero tolerance policing. It is one which imposes strict punishment for infractions or a stated rule with the intention of eliminating undesirable conduct. The next is the concept of law enforcement and policing. So, concept of law enforcement. It is a focus on the letter of the law rather than the spirit of the law. So, what we mean by concept of policing? The concept of policing requires a holistic approach to community service, taking into account the problems that plague a community and working a people within the community to solve them. Lesson 2. The police as the prime mover of the CJS or criminal justice system. These are the legal foundations of the Philippine National Police. First is Article 16, Section 6 of the Constitution. It means it provides that the state shall establish and maintain one police force, which shall be national in scope and civilian in character, to be administrated and controlled by National Police Commission or NAPOLCOM. Next is the Republic Act number 6975. It is an act that establishing the Philippine National Police under a reorganized Department of the Interior and Local Government, or the DILG, and for the other purposes also known as the DILG Act of 1990. Third is the Republic Act number 8551. It is an act providing for the reform and reorganization of the PNP and for other purposes, amending certain provisions of Republic Act number 6975, enacted on February 25, 1998, as amended by Republic Act number 9708. Fourth is Republic Act number 9708. It is an act extending for 5 years the reglementary period for complying the minimum educational qualification for appointment to the Philippine National Police and adjusting the promotion system thereof, enacted on August 29, 2009. Amending for the purpose pertinent provisions of Republic Act number 6975 and Republic Act number 8551. So there are two main functions of police officer. First is to serve and protect. We mean to serve and protect. The responsibility of every police officer is to serve the public and protect life and property. Next is to observe rights and dignity of a person. All PNP personnel shall respect the human rights and dignity of suspects during the police operations. Powers and functions of the Philippine National Police. First, maintain peace and order and take all necessary steps to ensure public safety. Next is investigate and prevent crimes, effect the arrest of the criminal offenders, bring offenders to justice, and assist in their prosecution. Third is detain an arrested person for a period not beyond what is prescribed by law, informing the person detained of all his rights under the Constitution. These three are just an example of the powers and functions of Philippine National Police. Next is the categories of police operations. First is public safety operations. So these include search, rescue, and retrieval operations, fire drills, earthquake drills, and similar operations that promote public safety. Next is the law enforcement operations. So this includes service of warrant of arrest, implementation of search warrant, and similar operations that are conducted to enforce laws, statutes, executive orders, and ordinances. Third is internal security operations. These include counterinsurgency operations, counter-terrorist operations, and similar operations that are conducted to ensure internal security. Fourth is special police operations. These include checkpoint operations, roadblock operations, and similar police operations that are conducted by police units with specialized training on the peculiarity of the mission or purpose. Fifth is intelligence operations. These include surveillance operations, counterintelligence, and similar police intelligence operations conducted to gather information related to security and public safety and order. Sixth is investigation operations. These include investigation of crime or incident and similar investigative work necessary to determine facts and the circumstances for filing cases criminally or administratively. Seven is scene of the crime operations, or SOCO. This includes the processing of crime scene, technical and forensic examination of evidence, and similar scientific investigative assistance. So, what are the requirements of police operations? First is, what are the basic requirements in police operations? During police intervention operations, the team leader shall police operations like arrest, search and seizure, checkpoint, roadblocks, demolition, and civil disturbance management shall be done as follows. First is with a marked police vehicle. Second is led by a police commission officer or PSO and with the personnel in prescribed police uniform or attire. Second is, what should police officers use during actual operations? During police intervention operations, the team leader shall use peaceful means, including the use of megaphones or any other similar instruments to warn or influence the offenders or suspect to stop and or peacefully give up. Third is, are warning shots prohibited? Yes, the police shall not use warning shots during police intervention operations. Use of force during police operation. First is use of excessive force prohibited. In the lawful performance of duty, a police officer may use necessary force to accomplish his mandated task of enforcing the law and maintaining peace and order. Second is the issuance of verbal warning. The police officer must first issue a verbal warning before he could use force against an offender. The verbal warning shall be in the dialect that is known to the offender or in the national language. Third is non-issuance of verbal warning. Non-issuance of verbal warning is excusable in case where the threat of life or property is already imminent and there is no other option but to use force to subdue the offender. Fourth is use of non-lethal weapon. When suspect is violent or threatening and that less physical measures have been tried and deemed inappropriate, you can use such as baton or truncheon, pepper spray, stun gun, and other non-lethal weapon to bring the suspect under control or effect of an arrest. Fourth is the application of necessary and reasonable force. During confrontation with an armed offender, only such necessary and reasonable force should be applied as would be sufficient to overcome the resistance put up by the offender. Six is factors to consider in the reasonableness of the first force employed. The reasonableness of the force employed will depend upon the number of aggressors, nature, and characteristic of the weapon used, physical condition, size, and other circumstances to include the place and occasion of the assault. Seventh is the responsibility of the police officers in charge of the operation. The police officer who is in charge of the operation shall at all times exercise control all over the police personnel in the area of operation and shall exhaust all possible means to apply the necessary and reasonable force to protect lives and properties during armed confrontation. Or what is the duties of patrol officers? First, attend the roll call formation before his tour of duty for briefing and likewise attended the after tour of duty formation for debriefing. Next is observe and monitor public gatherings, prevent disorders, and disperse unlawful assemblies. Third is prevent crimes and cited law violators. assuring the public that peace is preserved. Lesson 3. Arrest, search, and seizure. First is the arrest. These are the general guidelines. First, all arrests should be made only on the basis of valid warrant of arrest issued by a competent authority. Next, no violence or unnecessary force should be used in making an arrest, and the person to be arrested shall not be subjected to any greater restraint than what is necessary under the circumstances. Third, as a general rule, arrest can be made on any day of the week and any time of the day or night. Fourth is only judges are authorized to issue warrant of arrest. Last is a warrant of arrest is no longer needed if the accused is already under detention. So, there are two forms of arrest. First is the arrest warrant. What we mean by the arrest warrant? Or what is an arrest? Arrest is the taking of a person into custody in order that he may be bound to answer for the commission of an offense. How is arrest made? An arrest is made by an actual restraint of a person to be arrested, or by his submission to the custody of the person making the arrest. What is warrant of arrest? The warrant of arrest is the written authority of the arresting officer when making an arrest or taking a person into custody in order that he may be bound to answer the commission of an offense. Second is the arrest without warrant. So what is the arrest without warrant? Arrest without warrant is also known as the warrantless arrest. The instances of this are the following. First is caught in the act or in flagrante delicto. When in his presence, the person to be arrested that's committed is actually committing or is attempting to commit an offense. Next is the doctrine of hot pursuit, or when an offense has just been committed and he has probable cause to believe, based on personal knowledge of facts or circumstances, that the person to be arrested has committed it. Authority of the arresting officer when making an arrest. First is the police officer may summon assistance. A police officer making a lawful arrest may verbally summon as many persons as he deems necessary to assist him in effecting the arrest. Next is right of a police officer to break into building or enclosure. A police officer, in order to make an arrest with or without warrant, may break into a building or enclosure where the person to be arrested is or is reasonably believed to be. If he is refused admittance there to after announcing his authority and purpose. Third is right to break out from building or enclosure. Whenever a police officer has entered the building or enclosure to make an arrest, he may break out then from, when necessary, to liberate himself. Fourth is arrest after escape or rescue. If a person who is lawfully arrested escapes or is rescued, any person may immediately pursue to retake him without a warrant at any time and any place within the Philippines. Letter B is seizure, search and seizure. The privacy of home. The place where the man with his family may dwell in peace and enjoy the companionship of his wife and children unmolested by anyone, even the king, excepted in the rare cases, has always been regarded by civilized nations as one of the most personal rights to whom when are entitled. Hence, a man's house is his castle. Next is What is the purpose of the constitutional guarantee against unreasonable searches and seizures? The purpose of the constitutional guarantee against unreasonable searches and seizures is to prevent violations of private security of a person and property and unlawful invasion of the security of home by officers of law acting under legislative or judicial sanction to give remedy against such insertion when attempted. What is search warrant? A search warrant is an order in writing issued in the name of the people of the Philippines, signed by a judge and directed to a peace officer, commanding him to search for personal property prescribed therein and bring it before the court. Next is, what is probable cause of search warrant? It refers to the facts and circumstances that would lead a reasonable, discreet, and prudent man to believe that there has been a crime committed and the things and object connected to the crime committed are in the place to be searched. So, first, this is the validity of the search warrant. First is, the warrant should be valid for 10 days from date of issuance and may be served at any day within the said period. Thereafter, it shall be void. If in the implementation of the search warrant, its object or purpose cannot be accomplished in one day, the search can be continued the following day or days until completed. What time search warrant should be served? A search warrant should be served during daytime unless there is a provision in the warrant allowing service at any time of the day or night. Lesson 4. Right of a person under custodial investigation. Basis of right of person arrested. First is the Universal Declaration of Human Rights, or UDHR. The UDHR is the common standard of achievement for all peoples and all nations, to the end that every individual and every organ of society, keeping this declaration constantly in mind, shall be strived by teaching and education to promote respect for these rights and freedoms. First is the Article 1. All human beings are born free and equal in dignity and rights. Next is the Article 3. Everyone has the right to life, liberty, and security of person. Article 5. No one shall be subjected to torture or to cruel, inhuman, or degrading treatment or punishment. Next is the Article 7. All are equal before the law and are entitled without any discrimination to equal protection of the law. Next is the Article 8. Everyone has the right to an effective remedy by the competent national tribunals for acts violating the fundamental rights guaranteed by the Constitution or by law. Article number 9. No one shall be subjected to arbitrary arrest, detention, or exile. Article number 10. Everyone is entitled in full equality to a fair and public hearing by an independent and partial tribunal in determination of his rights by an independent and impartial tribunal and obligation and of any criminal charge against him. Article 11. Everyone charged with a penal offense has the right to be presumed innocent until proved guilty according to law in a public trial at which he has had all the guarantees necessary for his defense. Article number 12. No one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence, nor to attacks upon his honor and reputation. Last is Article number 17. Everyone has the right to own property alone as well as in association with others. No one should be arbitrarily deprived of his property. B. 1987 Philippine Constitution. What we mean by this? Article 3 Bill of Rights of the 1987 Philippine Constitution provides that the rights of every Filipino with some of its provisions are anchored on the UDHR. There's C. Republic Act number 7438. This act defines certain rights of person arrested, detained, or under custodial investigation, as well as the duties of the arresting, detaining, and investigating officers, and providing penalties for violations. Next is, what is custodial investigation? It involves any questioning by law enforcement people after a person is taken into custody or deprived of his freedom in any significant manner. What is extrajudicial confession? It is a declaration made voluntarily and without compulsion of inducement by a person under custodial investigation, stating or acknowledging that he had committed or participated in the commission of crime. The doctrine of the fruit of the poisonous tree. First is, what is silver platter doctrine? It is a doctrine which allowed federal prosecutors to use evidence illegally gathered by the state police to be a violation of the Fourth Amendment to the United States Constitution, prohibiting unreasonable searches and seizures. The Miranda warning or Miranda doctrine. What we mean by the Miranda warning or Miranda doctrine? The above provision in the fundamental charter embodies what jurisprudence has termed as Miranda rights, stemming from the landmark decision of the United States Supreme Court, Miranda v. Arizona. What is the Messiah doctrine? In Messiah, the defendant had been indicted on a federal narcotics charge. He retained a lawyer, pleaded not guilty, and was released on bail. Lesson 5. The police in the filing of criminal action. Two modes of instituting criminal action. First is the complaint. A complaint is a sworn written statement charging a person with an offense, subscribed by the offended party and any peace officer or other public officer charged with the enforcement of the law violated. Next is the information. An information is an accusation in writing charging a person with an offense, subscribed by the prosecutor and filed with the court. Elements of sufficient complaint. First is name of the accused. The complaint must state the name and surname of the accused or any appellation or nickname by which he has been or is known. Next is designation of the offense. The complaint should state the designation of the offense given by the statute. However, the acts of omission constituting the offense and specify its qualifying and aggravating circumstances. Third is cause of the accusation. The acts or omissions complained of constituting the offense and the qualifying and aggravating circumstances must be stated in ordinary and concise language, and not necessarily in the language used in statute, but in terms sufficient to enable a person of common understanding to know what offense is being charged. Fourth is place of commission of the offense. The complaint is sufficient if it can be understood from its allegation that the offense was committed or some of the essential ingredients occurred at some place within the jurisdiction of the court. Fifth is the date of commission of the offense. It is not necessary to state in the complaint the precise date when the offense was committed, except when it was committed, or any appellation or nickname by which such person has been or is known. Name of the offended party. The complaint must state the name and surname of the person against whose property that offense was committed. So, this is the question. Is duplicity of the offense allowed? No. A complaint must charge but one offense, except when the law prescribes a single punishment for various offenses. Next is each amendment or substitution prohibited? The answer is no. A complaint may be amended in form or in substance without leave of court at any time before the accused enters his plea. Third, place where criminal action could be instituted. First is subject to existing laws. The criminal action shall be instituted and tried in the court of the municipality or territory where the offense was committed, or where any of its essential ingredients occurred. Second is where an offense is committed in a train, aircraft, or other public or private vehicle while in the course of its trip. The criminal action shall be instituted and tried in the court of any municipality of territory where such train, aircraft, or other vehicle passed during its trip, including the place of its departure arrival. So, sir, that is the end of the presentation, end of chapter 2. And that's all. Thank you.